Can you believe this is the third time. Power went out, so this died. Cell phone was dying. Then power comes back on. So now I'm back on the proper platform to complete this live. And guess what, y'all? I'm going to start over from the beginning because I'm not going to be attaching all those three together. I ain't got time for all that technical stuff. Because as soon as I finish, I want to upload and be done with it. Islam at. So we're going to start back with Section 2. This is Sharon Tracey Gale Bey, Moorish American National, Supreme Judiciary Consul for the Moorish National Republic Federal Government, Northeast Amexem Territories and Dominions, the Moorish American Consular Court, Article 3 Jurisdiction and Treaty Jurisdiction, as well as what? The Moorish American Consulate, Islam Moors. So this is part 2 of County Sheriff Handbook. Part 2 of County Sheriff Handbook. We got all the way up to page 20 on the last broadcast. Not the one that we just had and we kept getting booted off, but the last one from the website. So again, the Moorish American Consulate website has been updated and we have a section called Erudite Lessons. It's called Erudite Lessons. And if you click on the video section, it'll take you right down to videos. And we have a class called County Sheriff's Handbook, and the actual handbook is right on that platform for you to download and view at your leisure. Islam? So we're going to go and start with the oath of office that they take. The sheriffs take an oath of office. They take an oath of office because they just got elected by the people to perform specific duties. They got elected by the people, which is why they hold an office. You cannot hold an office unless you were authorized by the people, the government, in order to operate in that particular capacity. That's what makes you an officer and not a policy enforcer, because a policy enforcer is not a police officer because he has not been commissioned by the people to perform said duties. He's not even added to the so-called statutes of the so-called state as a office. There's no such thing as a police office or a police officer. There is a such thing as a sheriff who is an actual officer because he was elected by the people to perform certain duties, and the oath of office is what they have to pledge before they can even enter the actual office with that delegated authority that they got from the people. Islam. So in the United States, the oath of office requirement of a sheriff is that he will support the Constitution for the United States of America. My platform keeps bugging out. I don't know what it is. It keeps bugging out. I don't know. I'm going to keep going. And will faithfully discharge all the duties of the office of sheriff to the best of his ability, including by calling upon God, which is government ordinances and departments, for protection and assistance in activating or enforcing the law. And what law is he enforcing? The Constitution. He's enforcing the Constitution. I've read a bunch of different documentations that were talking about what are the responsibilities and what are the powers of the sheriff. Well, what do you mean, what are the powers of the sheriff? The powers of the sheriff is to enforce the Constitution by lawful means, to support and defend the Constitution. That is his responsibility. So whatever he has to do in order to do his job, based on his office, as well as his oath, that is his responsibility. And understand that as a so-called sheriff, he has the responsibility to deputize employees or deputy sheriffs under his authority. They are being employed as a officer, a deputy sheriff, pursuant to his office, which he was elected. So he was elected as an officer of the law enforcement to enforce the law, which is the Constitution for the United States of America, and the constitutions for the state shouldn't be in controversy, and there shouldn't be anything within the so-called state constitutions that go against the Constitution for the United States of America, and it so stipulates that in the actual law. And I'm just bringing you back up to speed because we had to do this class twice in a matter of less than an hour because lights was going out, batteries were dying, all types of stuff was going on. So Amendment 4 of the Constitution, which is part of the Bill of Rights, says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath and affirmation, and particularly describing the place to be searched and the person and thing to be seized. Right? But you have to also have jurisdiction in order to do that. You also have to have jurisdiction in order to do that. And the sheriff has a unique responsibility, but he has a whole bunch of deputies to assist him in these responsibilities, which is the purpose of him hiring or deputizing individuals under his office as officers, deputy sheriff officers, whatever you want to particularly call them. That would be in compliance. And we talked earlier about Aeneas Prius Court. In the previous class, the class 1 of the County Sheriff's Handbook, Aeneas Prius Court is a court which will proceed unless the parties object. So you have to object to the proceedings, you have to object to the charge, you have to object to the jurisdiction of the court, or they make the presumption that you've given permission to proceed. Islam? Because agreement to proceed must be obtained before you can even consider me a so-called defendant or be a party to this so-called action. I have to agree to it. And if I don't object to it, therefore, by so-called common law or so-called presumptions, I waive jurisdiction. But we talked on prior platforms that you can't waive jurisdiction. Jurisdiction cannot be waived. You either have it or you don't, and it has to be entered into the record to validate and substantiate that. And these laws are established to assist people as well as to make sure lawlessness doesn't operate. But right now, because of everybody failing in their responsibility as it relates to the laws that govern peaceful societies, we have the situation that we have today. So Aeneas Prius Court is a court that upholds statutory state laws that are not laws of the country. And if you want to know what country we're talking about Morocco, y'all, because the United States is a federal corporation pursuant to 28 USC subsection 3002 15A. Again, 28 USC subsection 3002 15A tells you that the United States is a federal corporation. So they tell you in their own statutes and their own codes, oh, we're a federal corporation. We don't have jurisdiction over people. Unless they submit themselves to jurisdiction by calling themselves a United States citizen. That means they're property of us. And we have jurisdiction. Islam? So Aeneas Prius Court is not a court of law. And the sheriff shouldn't be executing any warrants handed down from them. They're not supposed to be doing that. It's a breach of their duty and it's a breach of their trust. And that is why you can lien them and you can charge them with a violation because they just violated the law. Moors, make no mistake, us identifying as Negro, colored, and black, the majority of our lives, we were in dishonor at first. So they could do whatever they want because we were not protected by any law. We were only protected, so-called protected, with the implication of being protected by so-called privileges that we may have had that the so-called corporate states gave us as wards, which is why they call Ward 1, District, which is why these names are utilized today. Your wards of held to Christian black codes with Taj Tariq Bey, Grand Sheikh Taj Tariq Bey talked about last Friday, when he was talking about the Christian black codes of 1724. Moors, you're being subjected today under those same codes because you refuse to honor your mother and your father by declaring and proclaiming your nationality. Islam? So Aeneas Prius Court, no order should be held or should be effectuated from Aeneas Prius Court that's holding up statutes against any Moorish American nationals. But as it relates to Negro, colors, and black who are outside of law, that's why they make that presumption. They're making that presumption automatically that Moors that have declared and proclaimed their nationality are what? They're making the presumption that they're black because we have a whole bunch of so-called tribal members who are still complying to those false paradigms and those false statutes, ordinances, the Christian black codes. Islam? All right. So it says, even if you wanted to effectuate a warrant, the sheriff is supposed to check that warrant for validity. It's supposed to look at that warrant and make sure it's lawful. And a warrant that is lawful has what? It's supported by oath and affirmation. And the warrant shall have probable cause to have been issued by a legally lawful body, court. Islam? And it has to have a judge's wet ink signature. Can't be a copy. Can't be a stamp. Has to be an actual copy. So the better question you need to ask yourself again, why are all of these organizations doing that? Why are they doing that? No warrant, including federal warrant, is to be issued without going through the sheriff's office. So are they going through the sheriff's office to make sure they're effectuating warrants that are lawful, pursuant to their oaths of office to support and defend the Constitution? Islam. The sheriff is the chief executive and administrative officer of a county, holding judicial cells and the like, right? We ain't gonna go there. That's loaded. We're not going there this class. We have a multitude of classes to go over. The sheriff is the chief law enforcement officer of the county and also proclaimed that the states retained an insolvable sovereignty. The sheriff is the people's last line of defense against governments gone rogue. And that's a weird statement or a misrepresentation, because government is the people. So are the people going wrong? I would say the people are the ones that went wrong. So if we go forward again to where we ended up last week, we ended up on page 20. We ended up on page 20, which started with statutes. Page 20 started with statutes. The following codes, aka statutes, are examples of legislation that protect the people's unalienable rights and imposes fines in prison or prison sentences upon elected and appointed servants who abuse their powers under color of law. The jury has the power and authority to change fines into restitution, and they should because currently the fines are simply used to enrich the state. They also have the power and authority to make the restitution or punishment greater or less. If the convicted is placed on probation or house arrest, they may and should be required to pay for those so-called services. Now, a jury of your peers are people who belong to the same nation, which is why Moors, they know you don't belong in their venue because you're not a citizen of their corporate state. And the law supports that under the rules of naturalization in the Constitution. If you want to be a part of that particular state, the state can't just grant you citizenship. It's a violation of the Constitution for the United States of America, which says the rules of citizenship for this organization, for this so-called government, is the rules of naturalization, and it's held at the federal level. Islam? So they're holding you to a so-called citizenship that is null and void. It doesn't even exist unless you submit to that so-called private contract. And that's only between you and that so-called organization. Islam? So you got 18 USC subsection 241. But didn't I say what the codes are for? I said what the codes are for. The codes are examples of legislation to protect the people's unalienable rights. So these codes are to protect you, Moors, when these so-called public agents violate your rights. And these are and they're out there for the public to know that, okay, if you do this, this, and this is what you can be held in contempt of. Islam? So we got 18 USC subsection 241. Conspiracy against rights. Now we hear about conspiracy all the time. Against your rights. So when they sit there and pull you over and try to call you and says license, registration, and proof of insurance, well, that's a corporate privilege if I was a member of your community or a member of your so-called state as a citizen, but I'm not a member of your state as a citizen. If it's in their statutes, if it's actually in their statutes, but if you read the statutes, 49 for PA, I think it's 39 for New Jersey, they're only talking about commercial activity. You only need that so-called driver's license for commercial activity if you're hauling goods or hauling people commercially. Outside of that, there is no law that supports your needing to get permission to travel. That's how you know you're under Christian black codes. Because you don't know the law, so therefore they turned it against you. Islam, because you haven't been enforcing it or enforcing them to do their responsibility, to do what they ought to do based on their own oaths of office, as well as based on their oath to the Declaration of Independence. They already pledged it. They keep pledging and pledging and pledging, but keep violating and violating and violating. And we, as the Moors, are the ones not holding them accountable. So conspiracy against rights. 18 U.S.C. subsection 241. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or the laws of the United States, or because of his having so exercised the same, or if two or more persons go in disguise, the disguise is a police officer acting under color of law on the highway or on the premises of another with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured. They shall be fined under this title or imprisoned no more than 10 years or both. And if death results from the acts committed in violation of this section, or if such acts including kidnapping or any attempt to kidnap, aggravated sexual abuse, or the attempt to commit aggravated sexual abuse, or attempt to kill, they shall be fined under this title or imprisoned for any terms of years, or for life, or both, or may be sentenced to death. So that's what these policy enforcers are doing to you. Conspiracy against your rights. So that's part of what you put in your what? You're going to put that in your lien. You're going to say 18 U.S.C. subsection 241. You're in violation of that because you're violating me with a code that's not even law. Because anything against the Constitution that the state establishes a standard for is non-withstanding. It's not withstanding. It's null and void. So he or she knows or ought to know the law, because even if you get to classes at those so-called academies, why aren't they teaching the Constitution? Why aren't they teaching the Treaty of Peace and Friendship? Why aren't they teaching the things that support you, Moors, and that supports any other? Because they darn sure are doing it for all these other so-called foreigners. They know all these other foreigners. They know the laws that support and protect them. Consul notification access. They know they're supposed to be contacting the consulate. They know you're not a part of their citizenry because the darn ticket doesn't even list you there. Doesn't say Moor. It says black. They have an option for what? Black or so-called white or so-called what? All those other ones that are on their documents. The fact that it doesn't say Moor, check Moor, lets them know you're outside their jurisdiction. Your documents won't have that on there because you don't have jurisdiction over a Moor. But you darn sure had jurisdiction over somebody who's outside of every jurisdiction. Islam, 18 U.S.C. subsection 242. Deprivation of rights under color of law. Whoever under color of law, statutes, ordinance, regulations, or customs willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or the laws of the United States, or to different punishments, pains, or penalties on account of such persons being an alien, or by reason of his color, race, than as prescribed by the punishments of citizens, shall be fined under this title or imprisoned no more than 1 year or both. And if bodily injuries result from the acts committed in violation of this section, or in such acts include the use, attempted use, or threatened use of a dangerous weapon, explosive, or fire, shall be fined under this title or imprisoned no more than 10 years or both. And if death results from the actions committed in violation of this section, or if any acts, including kidnapping or attempted to kidnap, aggravated assault, sexual assault, or attempt to commit aggravated sexual assault, or an attempt to kill, shall be fined under this title or imprisoned for any term of years, or for life, or both, or may be sentenced to death. That's 18 U.S.C. subsection 242. And we're reading 18, which is the criminal code. 18 is the criminal code for any violations that these so-called public agents perform. And when I say public agents, that means any corporation, any company that violates your rights in this manner can be held subject to these statutes. So it tells them all over the place, don't do this, don't do that, or you will be held liable for these. And Moors, this is why we tell you part of your notice of removals, before we can accept them, you have to lien them for violating your rights. And these are the conditions for which you lien them. Because in the record, didn't they lie about who you are? Because you state for the record who you are. Nobody else determines your descendability but you. But it has to be in alignment with the truth. Can't lie about it. So if you say you're a Moorish American national, you better be a Moorish American national. You better come through an Asiatic Stargate. Or if you don't, you better have citizenship paperwork to validate that you are adopted in to the Moorish nation as a Moorish subject ipso jure. 18 U.S.C. subsection 645. Court officers generally. Whoever, be a United States Marshal, a clerk, a receiver, a referee, trustee, or other officers of the United States courts, or any deputy, assistant, or employee of any such officers, retains or converts to his own use or to the use of another, or after demand by the parties entitled thereof, unlawfully retains any money coming into his hands by virtues of his office, relation, position, or employment, is guilty of embezzlement, and shall, where the offense is not otherwise punishable by enactment of Congress, be fined under this title, or no more than double the value of the money so embezzled. Embezzlement means stealing. Whichever is greater, or imprisoned no more than 10 years, or both. But if the amount embezzled does not exceed 1,000, he shall be fined under this title or imprisoned no more than 1 year. It shall not be a defense that the accused person had any interest in such monies or fines. So the better question is, Moors, do you know how they are in violation of 18 U.S.C. subsection 641? They call themselves a court. They're subject to the laws, 28 stat. They're subject, right? But they can only bring people in their court that are their citizens. Anybody outside their citizenry is a violation of jurisdiction. You only have jurisdiction in your own people. You don't got jurisdiction over anybody else. Islam? 18 U.S.C. subsection 654. Officers or employee of the United States converting property of another. They're doing this all the time when they kick you out your domiciles, when they ain't have authority to do that. When they hold you in their facilities, when the sheriff should never even received you, since he's over all the so-called prisons. He's over them. He should be making sure. Understand this. When you go to any so-called sheriff's office website, they have a listing of all the people that are supposedly in their facility. Why are they listing you as Negro, colored, and black? Why aren't they listing you as your identification that you presented at the time of being unlawfully arrested? Why isn't that on the record? And why did they fraudulate the records when they put you in the system? When they put you in a system under a so-called nom de guerre? Because you had identification to validate who you are. You had a nationality in travel identification card. You expressed for the public as well as to his partner, who is another policy enforcer, that you were a Moorish American national protected by the treaty. The treaty can be downloaded from any website, and it's codified under the public statutes at large of the United States of America. So it's part of the statutes that they're violating. They're violating the statutes that they're actually held and subject to. Being as though they took an oath of office. Being as though they are so-called citizens. Islam? Whoever being an officer or employee of the United States or of any department or agency thereof embezzles or wrongfully converts to his own use the money or property of another which comes into his possession or under his control in the execution of such office or employment, or under color or claim of authority, as such officer or employee shall be fined under this title, or or no more than the value of the money and property thus embezzled or converted, whichever is greater, or imprisoned no more than 10 years or both. But if the sum of embezzlement is less than 1,000 or less, he shall be fined under this title or imprisoned no more than 1 year. How are they doing that? Oh, they're when they try to pull you over for not having those commercial licensing, even though they're not partaking in commercial activity and they're not a citizen of the so-called corporate state because they're a foreign national. That is why they're charged with 18 U.S.C. subsection 654. They're taking your property and converting it. And how are they converting your conveyances? They're taking them into the impound, and if you don't get them out in a certain amount of days without producing a so-called registration of their so-called municipality, they keep your conveyance and sell it. That's why they're in violation of this. As well as if they unlawfully evict you from your own property, which they didn't have the authority to do because you put all the documentation on the record, and then they subsequently sell your property, the property that was in the darn domicile, as well as your actual domicile, your actual house. That's why they're in violation of subsection 654. Put these sections in your lien. This is why I'm liening you. In your corporate capacity, but then you lien them in their private capacity when they don't adhere to the law, even though you've been giving them all types of supporting due process of law. Supporting law. 18 U.S.C. subsection 872. Extortion by officers or employees of the United States. How are they extorting? How are they extorting you? I'm not going to keep reading these statutes because I'm going to get to the good stuff. How do they keep extorting you? Asking you for Federal Reserve notes of extortion by itself, because that is not a form of payment. Only gold and silver is a form of payment pursuant to the Constitution for the United States of America. And because you took all the people's gold, they don't have a way of paying you. That's why everything is prepaid. 18 U.S.C. subsection 1001. Statements or entries generally. A. Except otherwise provided in this section, whoever in any manner within the jurisdiction of the executive, legislative, and judicial branch of the government of the United States knowingly and willfully falsifies, conceals, or covers up by trick, scheme, or device a material fact, or makes or uses any false writing or document knowing the same to contain any material false, fictitious, or fraudulent statement or entry, shall be fined under this title and imprisoned no more than 5 years, or if the offense involves international or domestic terrorism, as defined in subsection 2331, imprisoned no more than 8 years or both. If the matter relates to an offense under chapters 109A, 109B, 110, or 117, or section 1591, then the term of imprisonment imposed upon this section shall be no more than 8 years. How are they doing that? How are they in violation of 18 U.S.C. subsection 1001? I could tell you. And I'm going to tell you. When you got pulled over, or when when one of their so-called citizens, which would still also be the so-called corporate state, would be the actual citizen who filed the grievance or filed the charges against you or the claims against you, they called you a citizen. Not only did they call you a citizen, in the original complaint that the so-called policy enforcer put into the system was that you were a Negro, colored, or black person. They didn't put your titles and nobilities in your appellations. Why? Because they know damn well that should have been kicked. They should never even have filed it. Because filing a false document is fraud, and they could be subject to 18 U.S.C. subsection 1001. Making any material false, fictitious, or fraudulent statement or presentation. Makes any use or false writing or document knowing the same to contain a material false fiction. Because when you got pulled over, you said you were a Moorish American national, you stated your appellation for the record, and they looked in their database, which was a violation again, because they didn't have the authority to go into that system and look to see if there was somebody matching your description in that database, because you present yourself. You told them who you are. Whatever was in their so-called database is a lie, is a fraud. And they know this. How you Present yourself when you are being unlawfully detained on the side of the road is where that matter should have ended. That's why you lean that policy enforcer as well as the so-called corporation that he works for, because he is human trafficking, as well as he is what they call it, a highwayman who goes upon the highway stealing people's stuff. That's what he is. He's doing that in disguise, because he's trying to say he's a police officer. He's not an officer. He never got elected by the people to put on a uniform and run around in the street and act like he has authority. He doesn't. The only thing that he is supposed to be doing is what? He's a security guard. He's a security guard for the so-called municipality, state, or corporation that so employed him. And that is the only authority he has with the people who are employed by that so-called corporation. So if you're not an employee of the municipality of whatever, he can't pull you over. He doesn't have authority or jurisdiction. And even if you were within that jurisdiction, he still would have rules and regulations and statutes that he would have to abide by. Islam? So when Albion's acting like highwaymen or pulling you over, they're pulling you over not because they're racially so-called profiling you. They're pulling you over because they know Moors who are identifying as Negro, colored, and black, one, ain't got no law that supports them, and two, don't know the law to help and defend them. Because if you did know the law to help and defend you, you wouldn't be running around talking about you Negro, colored, and black. You'd be operating in your nobility like all of us other Moors are currently doing. Islam? 18 USC subsection 1503. Influencing or injuring officer or jury generally. I'm not reading it because I want to get to some other stuff. I'm highlighting it. Plus, obviously, this book is downloadable. You can read it yourself. So I want to get to the good stuff because this book is long and I want to finish this class in hopefully 3 sessions. I don't think 2 is going to do it. I think 3 may be necessary. 18 USC subsection 1512B. Engaging in misleading conduct. Sometimes I'm going to read it because I think it's well worth reading. And I'm going to read this because I think it's well worth reading. 18 USC subsection 1512B. Engaging in misleading conduct. Whoever knowingly uses intimidation, threatens or corruptly persuades another person or attempts to do so, or engages in misleading conduct towards another person with the intent to influence, delay, or prevent the testimony of any person in any official proceedings, cause or induce any person to withhold testimony, or withholds a record, document, or other object from an official proceeding, alters, destroys, mutilate, or conceals an object with intent to impair object's integrity or availability for use in an official capacity, invades illegal process summoning that person to appear as a witness or to produce a record, document, or other object in an official proceedings, or to be absent from an official proceeding to which such person has been summoned by legal process, or hinder, delay, or prevent the communication to a law enforcement officer or judge of the United States of information related to the commission or possible commission of a federal offense, or a violation of conditions of probation, supervised release, parole, or release pending judicial proceedings, shall be fined under this title or imprisoned no more than 20 years or both. That was loaded. So are they obstructing this 18 USC 1512 when they try to not allow you to file your documents on the record? Is the clerk doing that? Yeah, the clerk's doing that. Are they violating you when you send your stuff certified return receipt, and it doesn't appear on the record stamped? Isn't that a violation? Absolutely. Is it a violation when they fraudulate the documents? All of these things they're guilty of. 18 USC subsection 2071. Concealment, removal, or mutilation generally. Kind of goes into what I just read. I think I'm going to read this. Whoever willfully and unlawfully conceals, removes, mutilates, obliterates, or destroys or attempts to do so, or with the intent to do so, takes or carries away any record, proceeding, map, book, paper, document, or other thing filed or deposited with any clerk or officer of any court of the United States, or in any public office, or with any judicial or public officer of the United States, shall be fined under this title or imprisoned no more than 3 years or both. Whoever having the custody of any such records, proceedings, map, book, document, paper, or other thing, willfully and unlawfully conceals, removes, mutilates, obliterates, falsifies, or destroys the same, shall be fined under this title or imprisoned no more than 3 years or both, and shall forfeit his office, and be disqualified from holding any office under the United States. As used in this subsection, the term office does not include the office held by a person as a retired Air Force member of the United States. I can tell you several examples that the deputy sheriff of Delaware County is guilty of 18 U.S.C. subsection 2071. And I could share that on this platform, but he's already been served, and he's already been leaned in his public and his private capacity. It's already been done. And because it's already been done, I don't really feel the need to tell you this, but there's ways of validating when a record is false. When someone presents you with false documents, it is your responsibility to validate that document is real or not. As in Moore, it's our fiduciary responsibility to make sure these so-called individuals, him appointed, because he's not the actual sheriff. The actual sheriff is elected by the people. He's appointed by the sheriff. So he's an employee of that office, that sheriff's office, right? Fraudulating documents. How are they fraudulating documents? Well, when you can't find them in the record. Where you can't find a charge that so stipulates those documents. When you cannot find it in the record that is fraudulating, falsifying, all these things. 18 U.S.C. that I just read. Everything under 18 U.S.C. subsection 2071. I'm not going to go that far to say stuff because I've already done stuff that needed to be done as it relates to that. Again, this class is not just for Moors to get competent in the laws. It's also to all these so-called public officials, as well as these public employees, to get in alignment with the law as well. So it's for all who are doing business here at Morocco. 18 U.S.C. subsection 2076. 18 U.S.C. 2076. Clerk is to file. Oh my goodness. Do I have to read that? Clerk is to file. Everybody always asks me this question. Everybody's always asking me, well, when I went down to the clerk's office, they wouldn't find my documents. That's because you didn't know to tell them they have no response. The only job they had is to receive documents to file. And they don't have the prerogative to determine if they can or cannot file it. The only thing they need to be making sure is that if the person that's filing the document is the person that's filing the document. When I was being unlawfully detained and held at George W. Hill Correctional Facility for 18 months, when I was being unlawfully held there and violated in so many ways, I can't even express to you on this public platform. 2 so-called agents that did not identify themselves called me down from the facility that I was being unlawfully detained from. They called me down to the so-called court, acting like I had court. And they asked me a question. They didn't say who they was, what agencies that they came from, show me identification. None of this. I'm sitting here like, well, what is going on? And they pushed the document in front of me. And I read the document. Actually, before I would even got a chance to read it, they asked me, well, is this you? Somebody came down here and filed this. Did you give them permission to file this? And I was like, well, give me a second. Let me read it. So I looked. I read the whole document. It was 2 pages. Took my time. Because under threat to arrest and coercion, I was quite perplexed. So this is January 2020. They called me down January 2020. And the actual date, I think it was on the 6th or something like that. The document was timestamped by, the document was timestamped by the clerk of courts. The document was timestamped by the clerk of courts for the 14th of January. The document was timestamped January 14th by the clerk of courts. It read that somebody filed a document giving the presumption that I retained an attorney to assist me. Now, being the smart person and the accountant I am, I always look at all of the things that would tell you without you even calling me down, that would give you the truth in the matter. The person that was supposedly an attorney on the document was named Mark T. Chappelle. Mark T. Chappelle. And he supposedly had a law firm in Pennsylvania, right up close to Harrisburg, Pennsylvania. I think it was Lebanon, Pennsylvania. Mm-hmm. And it said Hill and Hill in Chappelle. Mm-hmm. And it had a mailing location on there. Mm-hmm. Okay? So they asked me, did you tell this person to file this document? Moors, they wanted me to submit to jurisdiction. They were trying to get me to submit to jurisdiction. They were trying for 18 months. 18 months they tried. By fraudulating documents on the record. That was a fraudulent document the clerk of courts filed on the record, giving the presumption. So I, first of all, was like, well, who, are you serious? I'm sitting here, you call me down. I don't know who you are. You ain't identifying two Albion sons. Didn't identify themselves, just gave me a document. And then when I said, okay, well, when you look at the document, did I sign it? Did I autograph it? Do you see my autograph here on the document? In my head, I'm sitting here thinking, what, am I being played right now? The document was very ill prepared. I mean, it mentioned me as a Moorish American national, all these crazy things that it said. But I know better than to contract with an attorney because they're agents of the state. That's cool. They get their license from the state, which is permission to operate, permission to do from the so-called corporate state. Or they can't make their so-called appearances on behalf of people as power of attorney, which is why you don't contract with them. Islam? I say this to say that was in violation of 18 subsection 2071, concealment, removal, mutilation, fraudulent documents. And then again, I said, well, y'all record this building, right? Won't you record, see who filed it? It probably was the deputy sheriff of the department. I'm just going to say that for the record here. That's who I think filed it. Which is why you don't know who filed it. And that was only a couple days ago, and all you had to do was ask the clerk, who filed this document? And here's the better question. Why are you just allowing anybody to file documents on the record who ain't validating that they came from, they were here to represent me and had validation that they were here to represent me, which would be a what? Representation letter? A representation letter. So clerks, you shouldn't be just automatically filing things on records without validating that person is either speaking on behalf of Amor because they will have documentation to validate that, or they got representation. So the clerk filed something fraudulently, and she knew it was fraudulent when she filed it, as well as the person. You're supposed to be checking IDs. Why aren't you checking IDs? Do you have, I want to know who's filing this document. And if you're not the person who's so named in this so-called civil complaint, then who gave you the authority to come and file something? Because every so-called attorney that is contracted, they're supposed to have that on the record. Talking about law, Moors. This is why our people get violated, because they don't realize these people are fraudulating from the start to the finish. And to start with the original complaint. The original complaint was the first violation because they know darn well you wasn't a Negro, colored, and black person because you stated for the record and you had supporting documentation to validate that, which is why we tell you put your nationality documents and a copy of your nationality identification cards filed with the clerk under that so-called libel. And we call it a libel because you don't have the authority to charge. It's a libel. Islam? 26 USC subsection 7214. Offenses by officers and employees of the United States. Unlawful acts of revenue officers or agents, any officer or employee of the United States acting in connection with a revenue law of the United States who is guilty of any extortion or willful oppression under color of law, or who knowingly demands other or greater sums than are authorized by law, or receives any fee, compensation, or reward except as by law prescribes for the performance of any duties, shall be dismissed from office or discharged from employment, and under conviction thereof shall be fined no more than $10,000 or imprisoned no more than $5,000, or both. The court may, in its direction, award out of the fine so imposed an amount not in excess of 1/2 thereof for the use of the informer, if any, who shall be ascertained by the judgment of the court. The court also shall render judgment against the said officer or employee for the amount of damages sustained in favor of the party injured be collected by execution. When Moors are being unlawfully held, they're being unlawfully held on fake charges because they don't have the jurisdiction to charge. And the so-called bail or bond far exceeds the so-called charge that they even try to impose on Moors. They're in violation of 26 U.S.C. subsection 7214. 42 U.S.C. subsection 1983, civil action for deprivation of rights. This is when your rights are being denied to you by a party that doesn't have the authority or a lawful warrant to so do the deprivation. Islam? Every person who, under color of any statutes, ordinance, regulations, customs, or usage of any state or territory or the District of Columbia subjects or causes to be subjected any citizen of the United States or other persons within their jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and the laws shall be liable to the parties injured in an action at law, suit in equity, or other proper proceedings for redress, except that in any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, injunction relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. For the purposes of this section, any act of Congress applicable exclusively to the District of Columbia shall be considered to be the statutes of the District of Columbia. You know the answer to that. I'm going to keep going. 42 U.S.C. subsection 1985-3, conspiracy to interfere with civil rights. Well, we know more people, there's no such thing as civil rights, so I'm going to go past that because obviously Amendment 14, there's no amendments past 10. There's no amendments past 10 because that was the de jure, Congress and the de jure constitutional activities. So that's the only active and lawful, positive public law that you have to adhere to. Pursuant to commercial agreements, that is. Title 42, subsection 1986, actions for neglect to prevent. And that's the last one, so I'm going to read it because it's the last one. I'm so happy it's the last one. Every person who, having knowledge that any of the wrongs conspire to be done and mentioned in section 1985 of this title are about to be committed, and having power to prevent or aid in preventing the omission of the same, neglects or refuses so to do, if such wrongful acts be committed, shall be liable to the parties injured or his legal representation for all damages caused by such wrongful acts, which such person by reasonable diligence could have prevented. And such damages may be recovered in an action on the case. And any number of persons guilty of such wrongful neglect or refusal may be joined as defendants in the action. And if the death of any party be caused by any such wrongful act or neglect, and legal representations of the deceased shall have such action thereof. and may recover not exceeding 5,000 damages for the benefit of the widow of the deceased, if there be one, and if there be no widow, then for the benefit of the next of kin, so of the deceased. But no action under the provisions of this section shall be sustained, which is not commenced within 1 year after the cause of action has accrued, right? So the clerks could prevent, the clerk administrators could prevent a lot of these fake and false libels from being added to the so-called docket by not accepting the freaking complaint, because it first goes to the court administrator. So when he gets these claims, one, he should be reading them. He should be reading them. And the reality is when Moors are being unlawfully profiled as a so-called Negro, colored, and black, these stupid agents so stated in the complaint. Violation. But they know darn well they are not supposed to be enforcing statutes on people who have constitutional and treaty protected rights. I'm talking about the clerk administrator by submitting and allowing these fraudulent documents to be submitted in. So that's how they're implicated in it as well. The clerk of courts, the court administrators, those people who work down in records, all these individuals are parties to it because they're being a party to it. It's called RICO, right? RICO is when all these people conspire together to do fraud. And they're all conspiring together to make money for their corporation. Islam? What is an oath? Any form of attestation by which a person signifies that he is bound in conscience to perform and act faithfully and truthfully. A solemn appeal to the Supreme Being in attestation of the truth of some statement. An external pledge or asseveration made in verification of statements made or to be made, coupled with an appeal to a sacred or venerated object, in evidence of the serious and reverent state of mind of the party, or with an invocation to a Supreme Being to witness the words of the party and to visit him with punishment, if they be false. If they be false. Political. What's political? Pertaining to the exercise of the functions vested in those charged with the conduct of government. Relating to the management of affairs of states as political theories, or of pertaining to exercise of rights and privileges of, or the influence by which individuals of a state seek to determine or control its public policy, having to do with organization or action of individuals, parties, and interests that seek to control appointments or actions of those who manage affairs of the state. Politics is the science of government. Rights and sovereignty. Somebody asked me, what's sovereignty? How are you sovereign? If you don't know the answer to that question, you might want to step down from positions of power, if you so have one. Islam. Sovereign is defined in Black's law as a person, body, jury, or state in which independent and supreme authority is vested. A chief ruler with supreme power, a king or other ruler with limited power. Whereas sovereign authority is vested in we the people through unalienable rights by nature of God, and sovereign authority was vested in the state through the Constitution by we the people. And only a sovereign power can establish authority and can give delegation of authority. So the question, boys, do you know who was that sovereign power that established the Constitution, the Treaty of Peace and Friendship, the Iroquois Confederation, all of these things, Moors? That's why you are the sovereigns. You are the heirs of the sovereign who established order here. And when we talk about the Constitution and the treaty, these are what? Commercial agreements. You ain't supposed to be the commodity. You're not the commodity under these commercial agreements, Moors. You're not supposed to be subjected as commodity under these commercial agreements, which is why nationality is definitely necessary, so Moors can stop operating against their own selves as Negro, colored, and black. Somebody asked me a question earlier today, had me fired up. That's why I was posting those things on platform. Moors, You know who violated you first? It wasn't you declaring and proclaiming your nationality and being a Moor. It was your mothers and your grandmothers and your great-great-grandmothers and your great-great-great-grandmothers, because they didn't tell you who you were. They didn't tell you your culture. They didn't tell you. They subjected you to these corporations as property. They did that. Now, were they conscious of it? Not necessarily, were they? I'm not going to give all of our elders a pass, because some of them were. Many of them were. The fact that every other nation is operating in their nobility and Moors operating as Negro, colored, and black are the only ones outside of that, and the only ones being violated by it. And even in that so-called privilege that you have, your sons and daughters are being violated and killed and destroyed, even though you gave consent to be a resident. So what are you scared about? What are you scared for? You are the ones violating us. I also put a post saying, this war is not against Asiatics and Albions. This war is against Asiatics, Moors, and black people. That's the fight. Getting our Moors that are sinfully classifying as Negro, colored, and black to stop being Negro, colored, and black. And a part of that is knowing that you're Negro, colored, and black, knowing that you're subject to those Christian black codes, and knowing that the only thing that's going to free you is you by declaring and proclaiming your nationality. And there you can hold all these Albions accountable for the laws that you've been breaching first. You've been breaching it first because you've been identifying outside of your nationality and your culture and heritage. And ignorance of the fact that you didn't know who you were doesn't give you an excuse, because they don't care about that. When every time they shoot you down, put you in these POW camps on false color of law activity or color of law authority and color of law rights, whatever you want to call it. Do they care? They're profiting off of your ignorance. They're living comfortably on your estate while while our people running around like, what do they call them? Vagabonds and immigrants or refugees. There you go, refugees. You refugees in your own nation. That's what Martin talked about. Alien, and you at home and don't realize you're home and you're being violated by those who who your ancestors assisted in their liberation from Great Britain commercially, because they still have family over there that they conspire with. Not necessarily conspire with, they still have those bonds because that's where they come from. They come from another continent. Moors, you ain't come from Africa. This is Africa. Northwest Africa. This is Africa. Amexem is the ancestral name of this part of the Pangea. Is it Pangea? Yes, I think it is Pangea. One continent. Islam? Oh, my throat is killing me. Only people are sovereign, subject unto God alone, and have rights vested by God. Let every soul be subject unto the higher power, for there is no power but of God. The powers that be are ordained by God. Whosoever therefore resisteth the power resisteth the ordinance of God, and they that resist shall receive to themselves damnation. So what we're subjecting ourselves to now is man's law, a law a man established. Why are you subjecting yourself to that? Sovereignty is superlative, and thus admits to no degrees of sovereignty by definition. Sovereignty resides only in that one God, deriving no authority from another. In earth, men are ordained sovereign and subject only to God. Bureaucrats in their capacity are not sovereign and have no rights. They have authority given by the people, subject to the Constitution, and have a duty to speak when demanded by the people to give an account. So when we demand them give an account, when we ask them for a copy of their oath of office, it is their responsibility to give it because they were elected or appointed or they accepted the employment for which they have to comply pursuant to the Constitution, again, commercial agreement. The state cannot diminish rights of the people. The people can only stop enforcing their rights by not knowing them. The assertion of federal law rights, the Bill of Rights, when plainly and reasonably made, is not to be defeated under the name of local practice. Where rights secured by the Constitution are involved, there can be no rule making or legislation which can abrogate it. So you cannot, none of these so-called corporate states can legislate your rights away. They can only make suggestions, but like, well, I ain't even gonna say that. I ain't gonna say that because I don't want you Moors acting crazy. The legislatures cannot make laws. There can be no sanction or penalty imposed upon one because of their exercise of constitutional rights. It's your constitutional right to be left alone as long as you don't injure someone physically by wounding them pursuant to the Treaty of Peace and Friendship as it relates to Moors. You're fine. They shouldn't be coming in there knocking on your door, messing with you. They shouldn't be doing that. They shouldn't be knocking on your conveyance. Especially if you got Moorish tags, Moorish plates, Moorish stickers, Moorish flags hanging for your domicile. They know they're outside their jurisdiction and pursuant to the treaty, they need to go somewhere else. And they know this. They know you just woke up from having your head bashed in through those years of subjugation that our ancestors actually went through. So overstand, you're dealing with everybody's going through the Dorothy effect. I call it the Dorothy effect. Are you going through the Dorothy effect? That means, are you, Dorothy, you got your head knocked out and you ain't got no more sense? You thought you actually left Kansas? Are you the scarecrow and you scared every damn thing? Are you the heartless tin man and because you ain't got no heart, you ain't going to do nothing? Or are you a coward? Did I say them all? Dorothy bumped her head. The scarecrow just scared. The lion is a coward. And the tin man ain't got a heart. Which one of those are you? You got to be one of them if you're not operating in your nobility. The Dorothy effect, we all at one point suffered from. Knowledge gets rid of it all. Knowledge of self. And the laws that support, defend, and secure you in your constitutional rights to do what you want as it relates to commerce, as it relates to anything, as long as you're not offending another. Islam? Sovereignty itself is, of course, not subject to law, for it is the author and source of law. Understand the preamble to the Constitution. And I'm going to keep saying this till you get it. The Constitution is a commercial agreement. It's not to manage people or to rule over people in their private capacity. It is only how you are supposed to operate in commerce through commercial contracts, Moors. The Treaty of Peace and Friendship says, okay, if you a United States citizen and I'm a Moor, the consular courts is the proper venue to air out grievances. You can't be going to your so-called corporate municipal courts because they don't have authority over me. They only have authority over you if you want to subject yourself to such a thing. But why should you? You got the Constitution to support and defend you. Be yourself. Get in alignment. If you're a Moor nationalized, if you're a so-called immigrant and you don't know your nationality, or we don't have no treaty arrangements or agreements, how about get a treaty agreement or do your Moorish subject paperwork, which is also located on the website, so you can stop being in dishonor. Islam. Going to page 30. I didn't even tell you what pages I'm on. Thus, man, being no source, spring of law, is no sovereign. Thus, man being no... Therefore, God is sovereign, and man is vested by God to self-govern, and thereby the author of the Constitution, the law of the land by which all government servants are bound. This is what makes the United States of America different than any other nation. If we lose these truths, we lose our liberty. Right. Lost the truth, lost your liberty. Lost the truth, lost your liberty. Licensing liberty. Can you really license liberty? We just told you you have the sovereign right to do what you want and nobody can sit here and subject you to a statute, especially if you did not contract to be subjected. No state shall convert a liberty into a license and charge a fee therefor. No state shall convert a liberty into a license and charge the fee. Overstand, they're also trying to say in not so many terms, how you gonna sit here and tell them they gotta get this document when the Constitution says you can't create no laws that would subject them to have to get a license, which is why Murdoch versus Pennsylvania is there. No state shall convert a liberty into a license. You can't convert a liberty into a license. You can only stop knowing that you have liberty to travel upon the highways on your Moroccan estate, and these policy enforcers don't have the right to subject you to a licensing service. If the state converts a right or liberty into a privilege, the citizen can ignore the license and fee and engage in the right with impunity. What they're trying to say is like, okay, if you want me to buy your license, that means you can't pull me over for anything else. But if you don't know the law, you can't enforce the law. Therefore, you're subjected to these fake codes. Remedy for every injury. Remedy for every injury. William Blackstone, a legal maxim: every right when withheld must have a remedy. Every right when withheld must have a remedy. In every injury, its proper redress. In the third volume of his commentaries, page 23, Blackstone states 2 cases in which a remedy is afforded by mere operation of law. In all other cases, he says, it is a general and indisputable rule that where there is a legal right, there is also a legal remedy by suit or action at law whenever that right is invaded. And afterwards, on page 109 of the same volume, he says, I am next to consider such injuries as are cognizable by the courts of common law, and wherein I shall be the present, only remark that all possible injuries whatsoever that did not fall within the exclusive cognizance of either the ecclesiastical, military, or maritime tribunal are, for that very reason, within the cognizance of the common law courts of justice. For it is settled an inviolable principle in the laws of England that every person, when withheld, must have a remedy in every injury, its proper redress. That's Marbury versus Madison. The government of the United States has been emphatically termed a government of law and not of men. It will certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right. Statutes which would deprive a citizen of the rights of person or property without a regular trial, according to the course and uses of common law, would not be the law of the land. That's Hoke versus Henderson. The right to be let alone or left alone, the most comprehensive rights, and the right most valued by civilized men. To protect that right, every unjustifiable intrusion by the government upon the privacy of an individual whatsoever, the means employed must be deemed a violation of the 14th Amendment. And I would say 14th not amendment. And I already told you why. There's no such thing as a amendment past 10. So you only got 1 through 10. Positive law. Everything else is private commercial. It is private commercial because that's when the corporate United States was established sometime after that. So you can use 1861. Anything established after 1861, if it's not in harmony with the Constitution, is notwithstanding. They don't have the right to make any laws that they were not delegated the authority to do pursuant to the Constitution, which is an indentured agreement. Islam? Congress cannot alter rights. Didn't I just say that? On the other hand, it is clear that Congress cannot, by authorization or ratification, give the slightest effect to a state law or constitution which is in conflict with the Constitution for the United States of America, and that's under 16 American Jurisprudence, 2nd edition, section 258. And why are these documents? You got to go to a law library to see why are these not available everywhere, and why are they not downloadable from the websites. Why do you have to go to Westlaw? Why is Westlaw the owner of American jurisprudence? There's thousands of, I don't think it's thousands, but there's hundreds, or even, I don't even know if it's hundreds, but there's a lot of American jurisprudence books on law. And you wonder why they're not available at your leisure unless you go to a law library, and they're not downloadable from the website unless you purchase a membership. That's a violation of the Constitution and the laws too, because that's our laws. We established them, we wrote them, and they should be available on these platforms for us at our will. That's the law. On the other hand, it is clear that Congress cannot, by authorization or ratification, give the slightest effect to a state law, or constitution which is in conflict with the Constitution of the United States for the United States. And where does it say that? Article 6, y'all. They can't give weight to a state statute. It's against their jurisdiction. Their jurisdiction is to adjudicate cases based on the Constitution for the United States of America. Jurisdiction, that's why they can't do that. It's a violation of the commercial agreement for the United States of America, the Constitution. It says any statutes of the state that go against or try to abrogate the law is notwithstanding. Which is why they should hear and try to put you in their quasi nius pria courts. Because they can't take you up to the federal district because they're going to lose. And they know they're going to lose, which is why they put them in their fake courts. Rights do not come in degrees. Although it is manifested that an unconstitutional provision in the statute is not cured because included in the same act with valid provisions, and that there is no degree of constitutionality. I'm going to read that again. Although it is manifested that an unconstitutional provision in the statute is not cured because included in the same act with valid provisions, and that there is no degree of constitutionality. States cannot license rights. You have a right. And the only reason they're trying to license this is what? Commercial financial improvement, financial gain. They're trying to create these statutes so they can and the statutes are only so they can create money and generate wealth for their so-called corporations. But they're not allowed to use you as a way of doing that. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that the flat license tax here involved restrains in advance the constitutional liberties of press and religion, and inevitably tends to suppress their existence. That the ordinance is non-discriminatory, and that it applies also to peddlers of wares and merchandise is immaterial. The liberties granted by the First Amendment are in a preferred position. Since the privilege in question is granted by the federal government or the federal Constitution and exists independently of the state's authority, the inquiry as to whether the state has given something for which it cannot ask a return is irrelevant. No state may convert any secured liberty into a privilege and issue a license and a fee for it. Murdoch versus Penn. Always know when I'm talking about the Constitution and the state constitutions, we're talking corporations, y'all. We're talking corporations that are their only goal is to make money for their board of directors, or who you want to call legislative branch. Their General Assembly. The General Assembly is a corporate name, or a so-called de jure name, or whatever name for the board of so-called directors. They're the board of directors, the trustees, or whatever for that so-called for-profit corporation, and their job is to make money. And unfortunately, because the people have been dumbed down so bad because of the schools they went to and the parents that raised them, they are at a deficit as to fixing the problem, which is competency. So you got the so-called federal corporation, then you got the so-called state corporations trying to make money. And that's all they're trying to do is make money and acquire wealth and assets. And they're using the people to do that because the people have dumbed themselves down to the point where they don't even know what corporations are, what a government is. They don't even know what nationality or status is. Majority people don't know this. And this is our issue. And this is why I say the Asiatics are fighting amongst each other, the ones that have nationalized through the ones that haven't, because they're not fearful, because they know the law and they're operating in that like manner. But then you got your Asiatic, Negro, colored, and black brothers, sisters, cousins, uncles, whatever, grandmothers who don't know the law and is scared because they're ignorant of the law. No other reason. And it's a choice, because it's an easy choice to be competent and ignorant. It's one or the other. Either you're going to be fearful and ignorant, or you're going to be competent and fearless. Which one you want to be? Where was I at? If the state does convert your right into a privilege and issue a license and a fee for it, you can ignore the license and the fee and engage the right in with impunity. So why are the policy enforcers pulling you over talking about, oh, you violated this right, or you violated this code? Well, because I got this dumb license, I'm immune to any persecutions based on the license. That's what this says right here. Shuttlesworth versus Birmingham, a 1962 Supreme Court ruling, says if a state converts a right to a privilege and licenses it and causes you to pay for it, how they going to then try to say, oh, you violated the law? It ain't a law. And I got this license because, what? Does that make sense? Interpretation in favor of the people. Any constitutional provisions intended to confer a benefit should be literally construed in favor and clearly intended and expressed designated beneficiary. And then a constitution should receive a literal interpretation in favor of the citizen. It is especially true and with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to person and property. That's in American jurisprudence again, y'all. Shall not infringe. Various facts of circumstances extrinsic to the Constitution are often resorted to by the courts to aid them in determining its meaning. As previously noted, however, such extrinsic aids may not be suited or resorted to where the provision in the question is clear and unambiguous. In such a case, the courts must apply the terms of the Constitution as written, and they are not at liberty to search for meanings beyond the instrument. If it says the Constitution, we're going to talk about this till we blue in the face. It's not for Moors. The Constitution is for those individuals who needed a form of government because they did not belong to one, and one was created for them at Morocco by the sovereigns to help establish a basis for them to be able to do business. So for them to be able to do business, they had to do it under us, the Moors. The preamble to the Bill of Rights. Congress of the United States begun and held at the city of New York on Wednesday, the 4th of March, 1789 year. That was 1789, y'all. The conventions of a number of states having at the same time of their adopting the Constitution expressed a desire in order to prevent misconduct or abuse of its power that further declaratory and restrictive clauses should be added. That's why the Bill of Rights are there. That's why the 10 Bill of Rights are there. And as extending the grounds of public confidence in the government will best ensure the benefit ends of its instruction. Resolved by the Senate and House of Representatives of the United States. And we're talking about the de jure United States before the coup in 1861 because of the war. In Congress assembled, 2/3 of both houses concurring that the following articles be proposed to the legislature of the several states as amendments to the Constitution of the United States, all or any of which articles which ratified by 3/4 of the said legislature to be valid to all intents and purposes as part of the said Constitution. Remember, we're talking about the sheriff, his powers, what he's supposed to be enforcing. That's what we're talking about. Pardon me. Articles. In addition to An amendment of the Constitution for the United States of America proposed by Congress and ratified by the legislature of the several states pursuant to the 5th article of the original Constitution. Courts are to interpret the people's vested rights in the understanding of the common law. Unalienable rights are the ruler that limits all statutes and all court decisions. If they don't measure up, they are null and void. Islam. So these amendments are what the so-called sheriff should be enforcing. They should be enforcing the rights of the people. They should be enforcing the rights of the people. They should be enforcing the rights of the people, and the authority that granted them this was their office being elected by the people to enforce the Constitution for the government for the United States, as well as the so-called state constitutions, as long as there is no controversy or no difference between the two. And if there is a difference between the two, you have to give way to the Constitution, period, point blank. Covert versus, I don't even remember the case. Can't remember the case number. And understand the Constitution. What's a part of the Constitution is the Treaty of Peace and Friendship, because it's a treaty that's enforceable by the Constitution. So the federal government has jurisdiction. The federal, whenever you contact the so-called Attorney General of the United States, their responsibility. They're supposed to assist. But the sheriff, if he has an issue with trying to get you out, he's supposed to go to the Attorney General to back his decision if he's not getting the support of the so-called policy enforcers. But you got all these sheriffs and deputy sheriffs under your tutelage. You shouldn't even be accepting in those facilities any Moorish American national, unless it's a violation of the treaty. And there's only one violation of the treaty Amor can do to require him to be detained. And the only issue is if they wound or kill a Moor or a Moorish or a United States citizen, which is a violation of Article 21 of the Treaty of Peace and Friendship. But you cannot hold them to any other constitutional amendments or any other so-called violations of the so-called corporate state, because that's notwithstanding, because it's a violation of the Constitution for the United States of America. 1781, 89, and ratified 1791. And it was ratified with its 10 Bill of Rights. Islam, which we're going to go over in a second. The 10 Bill of Rights. Understand, Moors. When we're talking about Constitution and contracts and all this stuff, I'm just going to go over it. I'm just going to stay in my lane. Congress shall make no laws respecting an establishment of religion, or permitting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for redress of grievances. Comment. For government servants to designate areas called free speech zones is an abuse. They can't do that. You have the ability, pursuant to the Constitution, to speak where you want to speak. They can't make specific zones for which you want to speak. They can't do that. It's a violation of the Constitution. Amendment 2. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. You can't even contract that right away, babies. That's why you're supposed to reserve your rights. All rights reserved. Under threat, duress, or coercion, are you autographing any documents, because they are known for violating your rights, because they've been doing it and they're used to doing it, and their organizations haven't trickled down the laws to them because they want them to aid in the bid. And it's supposed to be what? Plausible deniability? There's no such thing as plausible deniability, because if you don't know the law, you're still subject to it. Comment. Militia Act of 1792 passed May 8th of 1792 provided for the organization of the state militias. State militias. We're talking states. We're talking sovereign state militias. It constricted every free able-bodied male citizen between the ages of 18 and 45 into a local militia company. New York State Constitution Article 12, Section 1 states the defense and protection of the state and of the United States is an obligation of all persons within the state. Therefore, it is clear that it is the right of all people to own arms, and nothing is to infringe upon that. Licensing a right is an infringement running a background check before selling a firearm is not. How you figure that? That's a violation. I don't care what you say. How is that a violation? Answer that question. If I go to a so-called gun shop, right, and I want to purchase or buy an arm, because I have the right to be armed. If I want to buy one, you can't sit here and ask me to subject myself to a background check. Can you? It's a violation, right? It says I had the freedom to do that. So how you gonna sit here and try to run it? Exactly. I was like, wait a minute, he messed up in this document. That is a lie. He said, but background checks are infringements if one must wait for the results before being able to get his firearm. No, backgrounds are absolutely a violation of your rights. It's absolutely a violation of your rights. It's absolutely a violation of your rights. Because what they trying to tell you? What they trying to tell you? When you so-called plea guilty or are so-called found guilty of a so-called crime, they try to take your so-called arms away from you. Do they have the right to do that? Did you contract your rights away, and did you rescind that when you left? Hint, hint. Amendment 3, under threat, duress, and coercion. No soldier shall in a time of peace be quartered in house without the consent of the owner, nor in a time of war, but in a manner to be prescribed by law. That's Amendment 3. Amendment 4. The right of the people to be secured in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath and affirmation and properly describing the place to be seized and the person or thing to be seized. Well, if you don't got authority or jurisdiction over the person, the being, because they're a foreign national, you don't have the authority to issue a warrant. Did you hear what I said? If you don't have jurisdiction over the persons, and I'm not talking those other persons, I'm talking about the man, which is both masculine and feminine. If you don't have jurisdiction over them because they're foreign to your jurisdiction, you don't have the authority to issue a warrant. Your warrant is null and void. But I'll continue. Comment. According to the Black's Law Dictionary, the word oath, in its broadest sense, includes all forms of attestation by which a party signifies that he or she is bound in conscience by a solemn and formal declaration or asseveration that an affidavit is true. No warrants, including federal warrants, are to be served without going through the sheriff's office. Any warrant without a sworn affidavit and a judge's wet ink signature, not a stamp, is not an acceptable warrant. It is the sheriff's duty, again, listen, because this whole class is about the county sheriff's responsibility. It is the sheriff's duty to make sure that, as well as all deputized under his office, it is the sheriff's duty to make sure that all warrants, federal or state, served within their county passes constitutional scrutiny. That's why you're calling the sheriff's office, and they said, "Oh, why are you calling me out? What? Why are you calling me? This is a civil dispute. You are a constitutional officer. You are a constitutional officer. And this policy enforcers that's standing outside of this man's house don't have the authority to be pulling him over. You need to go find out what the heck's going on over there. As the constitutional officer, as the head law enforcement agent officer of that so-called corporate state, territory, county, whatever you want to call it. Amendment 5. No person shall be held to answer for a capital or other infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in land or naval forces or in the militia when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or liberty, nor shall be compelled in a criminal case to be a witness against himself, nor be deprived of life, liberty, or the pursuit or property without due process of law, nor shall private property be taken for public use without just compensation. Now, an infamous crime, y'all, in a capital crime. A capital crime is one that could subject you to the death penalty. That's what a capital crime is. It's that severe that it could hold you, it could end your life. And then the other one, infamous crime, is any so-called crime where you're being held in any facility, any so-called detention facility, any jail. What do they call them? Other penitentiary. They used to call them they used to call them penitentiaries back in the day. An infamous crime is any so-called crime where they put you in a freaking facility. Infamous crime. So the better question is, when they get their so-called warrant, do they have the indictment from a grand jury to even file the charges? Because an indictment means that you got permission by the grand jury to file charges. Am I right or am I wrong? A grand jury indictment means you got permission by the people who you owe your allegiance to and your oath to. You have permission by the people through the grand jury to file charges of criminal neglect for an infamous crime, to hold them in any facility, right? Moors. First of all, how is a policy enforcer pulling you over without a warrant? How's he doing that? He ain't even supposed to be pulling you over. Because as we already said, the traffic so-called codes and the driving so-called codes are state ordinances, and they're not supposed to be pulling you over. Did we just say that? And even if they knew who you were in the conveyance and they had a warrant, that warrant better be based on an indictment from grand jury where the charges were filed. They're ignoring all these constitutional responsibilities as a so-called policy enforcer, because even policy enforcers takes oaths of affirmations to the constitutions. Based on what we've read, it says, yeah, they both take the same oath. So if they take the same oath, they already took an oath to that Treaty of Peace and Friendship, pursuant to the Constitution for the United States of America under Article 6. Already took it. And we already know that it's part of the United States statutes because it's in the United States Stat Book. That's why it's codified under volumes. Like for the Treaty of Peace and Friendship, both of 1787, as well as 1836, is codified under Volume 8. Volume 8 of the United States Statutes on pages 100 through 104 for the original treaty of 1787, as well as pages 484 through 487 of the same volume for the updated treaty, which is still in force today. So why are they pulling you over, Moors? Why did they create the fake United States, the Kingdom of Morocco over there in off the continent? Why they create that in 1956 and trying to say, oh, they talking about those Moors? How are they talking about those Moors? That so-called corporation wasn't established until 1956. So try again. You didn't even try hard to try to hide the fact. You just thought we were that stupid that we wouldn't realize that was just enacted in 1956. This treaty predates their establishment, their creation. Are you really serious? You really gonna call me an idiot to my face? You really gonna sit here and use 1956 when the treaty is 1787, originate prior to that? Are you serious? Amendment 5. No person shall be held to answer for a... Oh, we just read that, right? An infamous crime. They're supposed to have a presentment from a grand jury to file those charges. Guess why? Why do they need authority before they can file charges? Because it's a government of the people, right? Why do you need authority? Oh, make sure y'all doing your job. It's our job to make sure y'all doing your job. So of course it should be a grand jury. So you can't sit here and just file fictitious charges like you've been doing to the Moors, misclassified as Negro, colored, and black, as well as to the Moors who've already collected their status. You try and act like you don't know what's going on. Really? Amendment. Wait a minute. No one can be sentenced to jail without first having due process, which means being indicted and tried by a jury of 12 and not by judge or tainted jury. A tainted jury is a jury not of your peers, Moors. Ain't nobody else of your peers. It's either Moors or Moors. Ain't nobody else being a jury in our empire. I'm just gonna say that for the record. Bias. It's called bias. Amendment 6. In all criminal prosecutions, the accused overstand. What's a criminal prosecution? What is a crime, y'all? Do y'all know what the definition of a crime is? Do I gotta read it? You know what a crime is? They try to act like, oh, this is a criminal charges. Nope, ain't no such thing as criminal charges if there's no injured party. There's no such thing as a criminal charge if there's no injured party. There is no such thing as a criminal charge if there's no injured party. It's a civil case. They're trying to attack your estate. No such thing. I can't stand when people try to act like I'm stupid. When these administrators administrative clerks that are not judges because they are not competent to be judge. Because if they were competent to be judge, most people wouldn't even be in their venue. Because they would throw out all these cases because they were fraud. If they were competent. Crime. What is a crime? Since I have to read it. I'm going to read the definition for y'all. It's just funny. A positive or negative act in violation of a penal law, an offense against the state. Did you defend the state? Because we already validated that they're not a state because they weren't authorized by the sovereigns, which are the Moors. They're not a state. They're a corporation. So, there's no offense. Is there? In a penal law? Penal law? Let's look at penal. You're not a state, but you're claiming that something offended you. How are Moors offending the state? Or corporate state? How are you offending the corporate state? You ain't even got a contract that you violated. Entered on the record to validate that. Nothing. Here we go. Penal laws. And the penal law is those which prohibit an act and impose a penalty for the commission of it. I'm not going to go far down the rabbit hole because we have a bunch of pages to get through. I think it's funny because for a crime to be committed, there had to be a violation. And because you're not subject to the so-called corporate state, you ain't violate the state. I'm not a citizen. Black Dress Guy already told everybody that you had to go through the Constitution. And if you got to go through the Constitution, the state can't make a citizen. And I wasn't born as a so-called heir to your citizenry. So for me to be a member of your so-called state, I got to go through the rules of naturalization. But why would I do that? Because when we talk about the Constitution, aren't we talking commercial? Why would I want a commercial contract to be a part of your state? When I have sovereign rights to be an heirship to the Moroccan Empire, that don't make sense for me to do that. I see the way you treat your people. Why would I want to give away my sovereignty and my birthright and all the things that I have to be subjected to what your citizens are subjected to? Why would I do that to myself? Sometimes we got to ask ourselves these basic questions. Or ask them these basic questions. Why would I want to be a citizen of your state? Y'all are horrible to your people. Or to your property. You don't know how to take care of property. It'd be different if you knew how to take care of property. Maybe I'll think about it, but why would I do that? Why would a Moor do that? Just saying. In all criminal proceedings, the accused shall enjoy the right of a speedy and public trial by an impartial jury of the state in district wherein the crime shall have been committed, which district shall have been previously ascertained by law, or to be informed of the nature and cause of the accusation. So yeah, you gotta be informed of the nature and cause of the accusation. I have to be a part of your jurisdiction, and I'm not. So how can you criminally prosecute me. And there's no injured party that I can confront for a redress of grievances and to be confronted with the witnesses against them. How can I be confronted to the witnesses against me when the so-called plaintiff is a so-called corpse? It's a corpse. Because the plaintiff in all of these cases are the so-called corporate state. How can I confront something that doesn't exist? Because wait a minute, there was supposed to be an actual injury, and there's supposed to be an actual plaintiff who is a fleshing being who can be cross-examined. The Commonwealth of Pennsylvania or whatever corporate state who's trying to offend you can't stand on a stand. There's no person to stand there. And all criminal trials must be by an untainted, well-informed jury, meaning you can't be an ignorant citizen. And it does not say assistance of a bar attorney. It says counsel, which can be anyone the accused feel best to help defend them from the liable, right? Because in addition to that, it says, and to have the assistance of counsel for his defense. It says assistance of counsel. It does not say a bar licensed attorney of the United States of America. That's what the Constitution does not say. It says you have the right to assistance of counsel. So you can't dictate who I can call in to assist me in defending myself against these libels. And they know this. But you're in a Aeneas Prius court, right? You're in a Aeneas Prius court. You're in a court that's holding up statutes in violation of the Constitution. They're all in violation. And they're only in violation when you state for the record your status, when you hold them accountable, and you state that this is a Aeneas Prius court, you are a foreign national, and you have treaty protected rights that this court is required by law to support and to acknowledge. Islam? Amendment 6. In suits at common law, where the value in controversy exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in a court of any of the United States that according to the rules of common law. All jury trials are common law trials, aka courts of record. Amendment 8. Excessive bail shall not be required, or excessive fines imposed, nor cruel or unusual punishment inflicted. Solitary confinement, desealing, and refusal of medical needs, or psychological and physical destruction, and are therefore cruel and unusable punishment, among other things. Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So if it's not stated, you can't make a code or statute that states it. You can't put something in there that wasn't in there. You only have what's been enumerated. Outside of that, you ain't got no jurisdiction at all. That's what that's trying to say. The powers not delegated to the United States by the Constitution or prohibited by it to the states are reserved to the state respectfully or to the people. Everybody gets hung up on this one. We have many unalienable rights not mentioned above, such as the right to travel without a license, take medicinal or recreational drugs, deny courts not of record, carry firearms, etc. There's a multitude of rights that are not listed here. They just listed what they felt needed to be mentioned. But there's a host of other ones. So if they weren't delegated power to create laws based on travel, your right to travel, they can't create one. If it's not mentioned, you cannot do it. What's mentioned specifically says, based on what we just said, you absolutely can't go outside of this. And if we didn't say anything in this, you absolutely can't even bring that up. That's pretty much what they're saying with Amendment 10. The consent of the governed. that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That's the Declaration of Independence. And that's also part of the supreme laws of the land. They gave everything up for this standing at law. They gave it all up. We the people consent to government by exercising the following 7 unalienable rights. When we freely elect committeemen who choose the candidates who will be on the ballot, when we cast our vote at the ballot box, when we exercise our rights of recall, we are exercising our right as grand juris to indict or not, which is why a grand jury has to be convened. When we exercise our right as trial jurists to convict or not, when we exercise our right of nullification, and when we exercise our right of denying courts not of record. An Aeneas Prius court is a court not of record because they are, let's just say an Aeneas Prius court is a court for slaves. We might as well call them that because the only people subject to those statutes are slaves under the Christian black codes. By the aforesaid rights, we the people have total control and consent of government in the exercising of our liberties. Any infringement upon any of these unalienable rights is an act of war against the people, against the Constitution, and against God. I'm going to read that again. By the aforesaid rights, we the people have total control and consent of government in the exercising of our liberties. Any infringement upon any of these unalienable rights is an act of war against the people, against the Constitution, and against God. The people are entitled to the laws of nature's God. It talks about the Declaration of Independence. If it put their oath, I would have loved that part. The part where they gave their honor, even their heirs, everything they pledged everything. Read the Declaration of Independence. We're not going to go over it today, and I'm not going to read that today either. Informed jurors. We don't need to read informed jurors because they don't have jurisdiction to even adjudicate. They don't have a jurisdiction because you're outside their status, so all their jurors are also outside your outside jurisdiction when it treats to you. Islam? I was like, so we don't even gotta read jurors, but they should read it because they need to know what people should be called as jurors for their people. And I'm not going to read that. Only the people can file a criminal complaint. Oh, well, that was a good one. Only the people can file a criminal complaint. There are only 4 ways a court can hear a criminal complaint. 1 or more of the people sign a sworn affidavit that there has been an injury and seek a grand jury indictment. The sheriff or coroner can directly ask the grand jury for an indictment. A prosecutor on behalf of the government or the people can bring an accusation before the grand jury, and the grand jury can either indict or do nothing. The grand jury, by its own will, can investigate merely a suspicion that the law is being violated, or even because it wants assurance that it is not, and in its findings wrongdoing, it can present it to the court and it must go to trial. No one can second guess the grand jury unless the grand jury's actions violate another person's unalienable rights. It's a violation of the Constitution, right? So they're saying in order for any so-called criminal charges to be initiated, 1 or more of the people sign a sworn affidavit that they have been injured and seek a grand jury indictment. So the original criminal complaint has to start with a criminal complaint. Or a original complaint suggesting criminality by a so-called person. They have to submit that to the grand jury before they can get an indictment. And that's the only possible way for which charges can thus be filed. Consent of authority. We read in the Declaration of Independence, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Any authority our servants have is by our consent. If they act outside their authority, they are subject to criminal charges under United States Codes 42 and 18 and liable for damages under U.S. codes and common law. Consent to indict. The Fifth Amendment states no person shall be held to answer for a criminal or otherwise infamous crime where they can be subject to imprisonment unless on a presentment of indictment of a grand jury. This is not happening. This is a violation, and the sheriff's department is definitely responsible, but because all warrants are supposed to go through him, and when he receives a warrant for any so-called criminal accusations where a person can be held in a facility, he's responsible to make sure those charges as well as that warrant are hold up to the Constitution. And he can't defer this responsibility to the so-called prosecutor of the office because he's the prosecutor, the so-called administrator, clerk acting like a judge, as well as the attorney, as well as the clerks. They're all, well, not necessarily the clerks, but they're all so-called esquires or so-called attorneys under the same organization. And that's a violation of, oh goodness, it's a 26 subsection 455. Don't quote me on that. I'm going to find it and post it on the website. But I'm not sure. It's where they're all a part of the same organization and overstanding at the Bar Association. It's not a constitutionally licensed. It's not constitutional, meaning you can practice law, but you don't necessarily have to be an attorney. And you don't have to get a so-called bar's license. But by getting a bar's license, you're automatically subjecting yourself to be prejudicial when trying people. And we'll go over that later, and maybe they'll say it in here. Where was I at? The Fifth Amendment states no person shall be held to answer for a capital or otherwise infamous crime unless on the presentment of indictment by a grand jury. Therefore, our servant government requires the people to get an indictment, a grand jury. Judges, servants have no authority to make a ruling or a judgment on people, master, without people's consent in legal terms. When the judge of a court not of record asks you to do you understand, he means, do you stand under the authority of this court? So if you say yes, you just gave her jurisdiction over you. Nevertheless, if the person standing before the judge is not informed of the court's intent, the judge would be subject to charges or fraud because that's illegal. Only the people can judge. Our United States Constitution only authorizes common law courts, aka courts of record, not Nias Prius courts. A court of record removes the power of the judge to making a ruling. His or her role is that of the administrator of the court. The final decision maker is the tribunal, who is either the sovereign plaintiff or a jury. He doesn't make any judgments. He's not allowed to do it. Remember, the servant cannot rule over the master. Can the clay rule over the potter? Every man is independent of all laws, except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. Cruden versus Neal. Herein is liberty. If you do not give the court consent, they have no jurisdiction over you. Judges may judge in equity courts. Equity courts are contract disputes. Contract has to be presented on the record. If the dispute is over $25 or $20, both parties must agree to an equity court. Judges in equity courts must proceed under the rules of common law governed by American jurisprudence and United States Supreme Court decisions. And Moors, we know you're not giving jurisdiction. You're not giving jurisdictions because you overstand, and you're not submitting to jurisdiction because you have an appellation, not a name. You don't have a residence. You have a mailing location. You're in Morocco, the country of Morocco, because the country of the United States does not exist unless you are resident or property of them as Surety. I said a lot. I know. Common law is the law of the land. What is common law? Let's see if I can tell you what common laws, or we can come to that agreement, because you know what common law is. It's Constitution and Treaty of Peace and Friendship, and the treaties amongst nations. That's what common law is. I just want you to. Common law is a law that's common, that treats to both parties. That's what's common. It's common because we both agreed to it. Because anyway, I'll go read it. I'll go read common law. Common, usual, ordinary, accustomed, shared among several, owned by several jointly, belonging or pertaining to many or to the majority, generally or prevalent. That's just the word. That's just what common means. So when we talk about law, common law, common law. Don't put more on this word than that's there. Okay? Familiar, reasons of frequency. What's common law? So here's the question, Moors. Type into the comment section, what is common law? I'll wait. I'm going to read the definition of common law. Black's Law Dictionary, page 345. As distinguished from the Roman law, the modern civil law, the canon law, and other systems, the common law is that body of law and juristic theory which was originated, developed, and formulated and is administered in England and has obtained among most of the states and people of the Anglo-Saxons. As distinguished from law created by the enactment of legislatures, the common law comprises the body of those principles and rules of action relating to the government and security of persons and property which derive their authority solely from usages and customs of immemorial antiquities, or from the judgments and decrees of the courts recognizing, affirming, and enforcing such usages and customs. I thought you was going to give me example of common law. What's common law? What do you enforce at law? What's common law, Morris? I just want you to know. You already know the answers. What we're talking about today. You know, we over-belabor these more. I know the etymology, Abdullah Bey is doing an etymology class, and it starts on the 17th, Morris. Take the damn class. Please take the class. It's a 12-week course. It needs to be 12 weeks because etymology is not very, it's simple once you have it, but to get it, because most Moors as well as Albions are at a deficit as it relates to nationality. Shucks, everybody need to take etymology if you ask me. I was like, because you need to know the basis for etymology. I just ain't taking the class because I ain't got time to take the, I don't know, I might take this on Thursday, y'all. I don't know. Maybe I will take the class. I don't know. I'll call it Abdullah. But take the damn etymology class. The Bill of Rights, that's common law. Okay, so too is the Constitution, which is a part of, the Bill of Rights is a part of. So is the Treaty of Peace and Friendship. It's common. They try to act like it's not common, but the Treaty of Peace and Friendship is common law. Treaty, the law is the supreme. What's common law is the supreme laws of the land. That's common law. But also realize, if you don't know the law, let me stop. Whatever is common between the people is common law. So know the law. So what's common is actual law and not what's... I don't want to go down the rabbit hole with y'all, Morris. Where are we at? Common law is the law of the land. Look, I just gave you the answer and I... Exactly. Common law is the law of the land. I just said that. Supreme law of land. All cases which have been cited, Marbury versus Madison, to the Supreme Court have never been overturned. The Constitution was ordained and established by the people for the United States of America, aka government. Thus, government was created by an act of the people. Therefore, the creation cannot trump the creator. If any statement within any law which is passed is unconstitutional, the whole law is unconstitutional. Marbury versus Madison. Therefore, that statutes which would deprive a citizen of the right of person or property within a regular trial according to the course and usage of common law would not be the supreme law of the land. Hoke versus Henderson. Where rights secured by the Constitution are involved, there can be no rule making or legislation which would abrogate it. That's Miranda versus Arizona. Stare decisis. No emergency can give just cause to suppression of the Constitution. And I always say this. I actually had to say this to an actual attorney. He's like, "No, COVID. With COVID, we can do." No, you can't. You just violated everybody's rights by making them wear a mask. That's a violation of their rights. Companies trying to force you to get vaccinations before you can return to the work. Violation of your rights. What other? Not letting you. I don't know what other ones, but those are the two main ones. You ain't got to get no vaccination. You ain't got to wear no mask. Violation. You ain't got to submit to a test. Violation. While an emergency cannot create power, and no emergency justifies the violation of any of the provisions of the United States Constitution or state constitutions, public emergencies such as economic depression for especially liberal construction of constitutional powers, and it has been declared that because of national emergency is the policy of the courts of times of national peril so liberally to construe the special powers vested in the chief executive as to sustain and effectuate the purpose thereof, and to that end also more liberally to construe the Constitution diversion and classification of powers of the coordinate branches of the government insofar as may not be clearly inconsistent with the Constitution. Constitution must be construed to reference the common law. Summary proceedings are null and void. Yeah, you can't have no summary proceedings. If you want to sit here and call somebody in, you got to call. If you want to charge somebody with something, you can't have a summary, a so-called summary proceedings where they can't come and contest to whatever it is that they're so-called being charged. It's a violation of the Constitution. As to the construction in reference to common law, an important canon of construction is that constitutions must be construed to reference to the common law. The common law so permitted destructions of the abatement of nuisances by summary judgments, and it was never supposed that a constitutional provision was intended to interfere with its established principle. And although there is no common law of the United States in the sense of national customary law as distinguished from the common law of England adopted in the several states, in interpreting the federal constitution, recourse may still be made in the aid of the common law of England. It has been said that without reference to the common law, the language of the federal constitution would not be understood. That's American jurisprudence. Section 114. Supreme law is the basis of all law. All fiction of law is null and void. Nias Prius courts rely on statutes, which is fiction of law, which seeks to control the behaviors of the sovereign people who are under common law, not statutes, and who ordained and established the law. Therefore, legislators cannot legislate the behaviors of the people. No provision of the Constitution is designated to be without effect. Anything that is in conflict is null and void of law. Clearly, for a secondary law to come in conflict with the supreme law was illogical. For certainty, the supreme law would prevail over all other laws, and certainly our forefathers had intended that the supreme laws would be the basis of all law, and for any law to come in conflict would be null and void of law. It would bear no power to enforce. It would bear no obligation to obey. It would purpose to settle as it would have never existed. For unconstitutionality would date from the enactment of such act, not from the date so branded in any open court of law. No courts are bound to uphold it, and no citizens are bound to obey. It operates as a near nullity, as a fiction of law. That's 16 American Jurisprudence, 2nd edition. The common law is the real law, the supreme law of the land. The codes, rules, regulations, policies, and statutes are not law. That's Self versus Ray. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. So this is the question. Why everybody scared or ignorant? One or the other. This class is to get everybody back into alignment with law. This class is so Moors, as well as Moorish subjects, as well as black people, as well as white people, stop operating outside of themselves. Islam? Islam. We are going to go to 4 o'clock, and then we're going to end this broadcast. And then I think we're going to have to, it's going to be 3 sessions to the Sheriff County Handbook. It's going to have to be 3 sessions. And I'll read this last section, and then I'll do some highlights in a document that I was reading for the last several minutes of this broadcast. The general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, as in reality no law, but is wholly void and ineffective for any purpose since unconstitutionality dates from the enactment, and not merely from the date of the decision so braining it. An unconstitutional law in legal contemplation is an inoperative as if it never had been passed. Such a statute lives a question that is purposed to settle just as it would be had the statute not ever been enacted. No appeal of an enactment is necessary since an unconstitutional law is void. The general purposes or the general principles follows that it imposes no duty, confers no rights, creates no office, bestows no power of authority on anyone, affords no protection, and justifies no acts performed under it. A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. Persons convicted and fined under a statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one, and an unconstitutional law cannot operate to supersede an existing valid law. Indeed, insofar as a statute runs counter to the fundamental laws of the land, it is superseded thereby, since an unconstitutional statute cannot repel or in any way affect an existing one. If a repelling statute is unconstitutional, the statute which it attempts to repel remains in full force in effect, and where a statute in which it attempts to repel remains in full force, he said that twice, in effect, and where a clause repealing a prior law is inserted in the act, which act is unconstitutional and void, the provisions of the appeal or repeal of the prior law will usually fall with it, and will not be permitted to operate as repelling such prior law. The general principle stated above applies to the Constitution as well as to the laws of the several states insofar as they are repugnant to the Constitution and laws of the United States. And then we will start again on due process. Is on? So, all so-called, and we're going to call them statutes, codes, ordinances, any so-called law that's established by the so-called corporate states that goes against the Constitution is null and void. You can't make a wrong out of a right. I mean, you can't make a right out of a wrong. You just have to nullify the whole so-called state. I'm sorry, the so-called law. Is on? Throughout the history of the sheriff's office was recognized and the chief law enforcement officer in his shire or county. If you remember, I forgot the darn movie, Lord of the Rings, they were talking about shires and things like that. A shire is just another word for county. It lets you know where they originate. Over there, not over here. The requirement for training a deputy sheriff is specifically provided in the statutes. We're talking about state statutes because I was reading a whole bunch of different documents to validate or further give weight to what we already know. Case law provides that although a sheriff's primary responsibilities are to the court, the sheriff retains all of his common law powers unless abrogated by statutes. They haven't been abrogated by statutes, and understand that all of the so-called state constitutions, with the exception of a few, put the sheriff's office in their statutes as the actual law enforcement, and the policy enforcers are not there. So we know darn well they don't have the authority. They are corporate employees of the municipality for which they work. They're not a part of the county. Just saying. So the question is, why are the so-called policy enforcers taking what do you call them? Why are they taking people to prison or to the jails? It's the sheriffs that's supposed to be picking them up. Sheriff's supposed to be picking up what, from the police station maybe? So if they take them to the police station, they're not supposed to be taking them to the so-called county jail. It's supposed to be the sheriff. The sheriff shouldn't be accepting individuals that they don't have the lawful or legal authority to do so. And taking a so-called Moorish American national is a violation of the Treaty of Peace and Friendship, which is a part of your municipal code. It's a part of the statutes of the United States, therefore a part of the statutes of every so-called corporate state, because they're all under the same authority. Sheriffs retain all arrest powers. He had at common law with the supreme laws of the land, and he has the authority to enforce the criminal laws as well as the vehicle laws of so-called Pennsylvania. And I don't want to read too much of this stuff because it's a time to end the broadcast. It's long. So if there's no questions, we finally got through the second leg of the class, and we got one more leg of the class to go through the last 20 pages of the County Sheriff's Handbook. And this is our due process as the Moorish National Republic Federal Government, Moorish American Consulate, Moorish Consular Courts, to give all county sheriffs the responsibility to redress for grievances, as well as this is our due process to let you know what your responsibilities are if you're too lazy to read them for yourself. So this is notice of intent to lien, as well as notice of intent to prosecute any violators going forward. Once a Moorish American national has declared or proclaimed a nationality on scene, you are to cease and desist pursuant to the Treaty of Peace and Friendship and pursuant to the Moorish American Consular Court. And I, Supreme Judiciary Sharon Tracey Gale Bey, so give this command to all sheriffs who've been duly elected by the people. Islam? So definitely download the County Sheriff's Office Handbook, download the document, upload it, and send it to the sheriff's departments. Tell them you have a duty. But you know what? No, don't do that. I don't want y'all to do that because we're handling this. Don't do that. But at least know this handbook and be able to speak to it and let the sheriff know who you are. So maybe one of the individuals you need to be sending nationality documents to as well as the sheriff's department. But like, look, I'm Moorish American National Sharon Tracey Gale Bey, and I just letting you know who I am. So if there's any issues, I'm coming to you as the only constitutional officer operating within your so-called county, and I will hope you will administer your office with faith and within the law. Islam. Pax it to more peace and love. And happy holy day.